Hello friends and welcome to ePathshala. My name is Malika Seth and I am an assistant professor at the O.P. Jindal Global University. I will be discussing the module titled The Right to Food in the Indian Constitution and Case Law. This module will introduce students to the Constituent Assembly debates and constitutional provisions that address the right to food. It will also survey Indian Supreme Court case law on the right to live with dignity under Article 21. It concludes by discussing the Supreme Court's decision in PUCL versus Union of India 2001 and the significant interim orders that the Supreme Court has since issued on the right to food. The right to food is a constitutionally protected right in India. In PUCL versus Union of India 2001, the Indian Supreme Court declared that the right to food comprises part of the fundamental right to life under Article 21 of the Indian Constitution. This decision built on a series of cases in 1980s and 1990s in which the Supreme Court interpreted Article 21 not only to protect against the arbitrary taking of life, but also to provide a broader right to live with dignity. This brought various directive principles of state policy within the ambit of Article 21 and made them justiciable, even though Article 37 of the Indian Constitution states that they shall not be enforceable by any court. The expected learning outcomes of the module are as follows. After completing this module, students should know and understand: first, the Constituent Assembly debates and the constitutional provisions on the right to food. Second, jurisprudential developments towards the right to life with human dignity, including a constitutional right to food. And third, the PUCL versus Union of India case and the Supreme Court's major interim orders on the right to food. The first part of the module discusses the right to food in the Constituent Assembly debates and the Indian Constitution. While India gained independence from the British in 1947, it only adopted its Republican Constitution in 1950 after more than 2 years of debate within the Constituent Assembly. Given the poverty and high degree of inequality in India, there was no doubt that social and economic or socio-economic justice had to be addressed in the Constitution. Jawaharlal Nehru, who would later become India's first Prime Minister, stated that the Assembly's first task was to free India through a new constitution, to feed the starving people and to clothe the naked masses, and to give every Indian the fullest opportunity to develop himself. Yet, the question of whether to include socio-economic rights, such as the right to food, in the Constitution was a subject of debate among the members of the Constituent Assembly. Some members favored including socio-economic rights as justiciable rights, that is, rights that can be enforced in court. K.M. Munshi drafted the rights of workers and social rights, which included the right to a living wage and protection for women and children. Dr. B.R. Ambedkar, the chairman of the drafting committee, favored a social scheme to nationalize all major industries that would take effect 10 years after the Constitution was adopted. In the end, however, these views did not prevail. The Indian Constitution includes provisions on socio-economic justice, but they are framed as directive principles of state policies, that is, the DPSPs, and not as justiciable rights. This was proposed by B.N. Rao, an eminent jurist and scholar who served as constitutional advisor to the Constituent Assembly's drafting committee. Rao was tasked with studying the constitutions of other countries and sharing his findings with the committee's members. Drawing from the Irish model, Rao suggested that the Indian Constitution should avoid justiciable socio-economic rights and instead include a list of directive principles, non-binding guidelines intended to guide the government towards improving socio-economic conditions. The final version of the Constitution, which was adopted by the Constituent Assembly, divided fundamental rights, which are mostly civil and political rights, and the directive principles of state policies. Fundamental rights were placed in Part 3, while DPSPs were placed in Part 4. While Articles 32 and 226 of the Constitution allow the Supreme Court and the High Courts respectively to redress violations of fundamental rights, Article 37 makes clear that DPSPs shall not be enforceable by any court. DPSPs are non-justiciable because they represent aspirational long-term goals of the state that will be progressively realized. The Constitution sought to give elected representatives the flexibility to pursue these goals gradually and in light of resource constraints, without having the courts interfering in their enforcement. A few of the DPSPs directly relate to the right to food. Article 39, subclause A, provides in quote, "The state shall direct its policy towards securing that citizens, men and women equally, have the right to an adequate means of livelihood." Quotes closed. Further, Article 47 declares, in quotes, "The state shall regard the raising of the level of nutrition and the standard of living of its people and the improvement of public health as among its primary duties." Quotes closed. The second part of the module discusses the right to live with dignity under Article 21. In the early years of the Indian Republic, the judiciary upheld the dichotomy between fundamental rights and directive principles. However, following the emergency, which lasted from 1975 to 77, when fundamental rights were severely curtailed and the judiciary provided little protection against state excesses, a few Supreme Court judges took a new approach to fundamental rights in the 1980s. As Craig and Deshpande put it, in this period, the very purpose of the law itself was undergoing a transformation. It was being used to foster social justice by creating new categories of rights. These justices revolutionized the Supreme Court's approach to fundamental rights through both procedural and substantive innovations in the law. Procedurally, the Supreme Court adopted a series of innovations to ensure public access to the courts and greater judicial oversight over policy matters. These innovations would come to be known as public interest litigation, popularly known as PIL. Bandhuwa Mukti Morcha versus Union of India, 1984, illustrates some of these innovations. In this case, a 3-judge Supreme Court bench, led by Justice P. N. Bhagwati, initiated a PIL in response to a letter they received from an NGO urging the court to end the practice of bonded labor. Instead of issuing a single final judgment declaring bonded labor unconstitutional, the court adopted a doctrine known as continuing mandamus. This allowed the court to postpone a final judgment and periodically issue guidelines and interim orders to ensure government compliance with the relevant constitutional provisions. Thus, the court not only relaxed its locus standi requirements to allow an NGO to file a writ petition on behalf of bonded laborers, but also expanded the scope of its authority to keep the litigation open and monitor compliance with its orders. Substantively, the Supreme Court began to enforce the directive principles of state policy in the early 1980s. It did this by reading DPSPs into the fundamental right to life enshrined in Article 21 of the Indian Constitution. As discussed earlier, Article 37 makes clear that directive principles shall not be enforceable by any court. However, since Justice Bhagwati and few other justices on the Supreme Court were keen to devise new and creative remedies, Article 37 was sidestepped in the larger cause of promoting greater human dignity and socio-economic justice. In 1981, the Supreme Court, per Justice Bhagwati, declared that the right to life under Article 21 protects a broader right to live with human dignity. The court also stated Article 21 cannot be restricted to mere animal existence. Rather, it must include the right to the basic necessities of life and also the right to carry on such functions and activities as constitute the bare minimum expression of the human self. The court has built upon this judgment to enforce a number of new socio-economic rights within the right to live with human dignity. These include the rights to food, education, healthcare, and shelter. The third part of the module discusses the case titled PUCL versus Union of India. In PUCL versus Union of India 2001, the right to food was explicitly recognized for the first time as a constitutionally protected fundamental right. This case began as a writ petition filed by an NGO on behalf of millions of Indian citizens who were without adequate food following a famine. Relying on the Francis Correll case, the petition alleged that the Government of India, the Food Corporation of India, that is FCI, and the 6 state governments had violated the right to live with dignity under Article 21 with respect to these famine victims. Since food is a necessary thing to sustain a dignified life, the petitioners contended that the state had an affirmative duty to provide and distribute food to citizens affected by the famine. On 28 November 2001, the Supreme Court issued an interim order that expanded the scope of the right to life and recognized certain food schemes as legal entitlements under Article 21. However, the court did not end its inquiry there. As in Bandhua Mukti Morcha, it exercised a continuing mandamus and kept the litigation open to retain oversight on government food policy. In some instances, the court does not simply judge the validity of government schemes, but issues directives to the central and state governments on how schemes should be operated. For example, with respect to how food licenses to the poor should be regulated, the court instructed government authorities as follows. Licensees who A. do not keep their shops open throughout the month during the stipulated period, B. fail to provide grain to BPL, that is below poverty line families, strictly at BPL rates and no higher, C. keep the cards of BPL households with them, D. make false entries in the BPL cards, E. engage in black marketing or siphoning away of grains to the open market and hand over such ration shops to such other person organizations shall make themselves liable for cancellation of their licenses. The concerned authorities and functionaries would not show any laxity on the subject. A few other schemes instituted by the Supreme Court are worth noting. In its 28th November 2001 order, states and union territories were directed to implement the midday meal scheme. This would provide every child in government and government assisted schools with prepared meals that contain a minimum of 300 calories and 8 to 12 grams of protein each day of the school for a minimum of 200 days. In the same interim order, the court directed the state and union territories to implement the Integrated Child Development Scheme as well, popularly known as the ICDS. This scheme would ensure that every ICDS dispersing center in the country provides 300 calories and 8 to 10 grams of protein for each child up to 6 years of age and 500 calories and 20 to 25 grams of protein for all adolescents. Every pregnant woman and nursing mother was to be given 500 calories and 20 to 25 grams of protein, and every malnourished child would get 600 calories and 16 to 20 grams of protein. The states and the union territories were also ordered to implement the National Maternity Benefit Scheme by paying all pregnant women who were below the poverty line rupees 500 through the village sarpanch 8 to 12 weeks prior to delivery for each of the first 2 births. Further, these governments were directed to implement the National Fertility Benefit Scheme, in which a BPL family would receive rupees 10,000 within 4 weeks if the family's primary breadwinner dies. On 2nd May 2003, in a separate order, the court asked the Government of India to evolve a system to ensure that all poor families that are eligible are correctly identified as below the poverty line. It also ordered the cancellation of licenses to ration shop dealers if they did not open on time, overcharged in their pricing, retained ration cards, made false entries in BPL cards, or engaged in black market activity. States which did not implement the midday meal schemes were ordered to provide midday meal schemes in at least 25% of the districts, with maximum priority given to the poorest districts. Today, more than 13 years after it began, the PUCL versus Union of India case remains open and has expanded greatly. The litigation now includes all 28 Indian states as respondents, and the court has issued more than 50 interim orders requiring state governments to implement policies on a range of matters, not all of which relate directly to food production or distribution. Interim orders have dealt with issues such as urban poverty, the right to employment, and general issues of government accountability and transparency. In the end, to conclude, let's recap the important points of the module. Today, the right to food is a fundamental right in India that is enforced by the Supreme Court. This was not the case prior to PUCL versus Union of India 2001. The drafting committee of the Constituent Assembly, on the advice of B.N. Rao, separated provisions on socio-economic justice from those on fundamental rights. Fundamental rights were placed in Part 3 of the Constitution and could be enforced in court. Directive Principles of State Policies, or DPSPs, were included in Part 4 and were explicitly non-justiciable. The DPSPs were drafted as aspirational policy goals to be progressively realized by elected representatives without any judicial interference. However, the division between Part 3 and Part 4 of the Constitution has gradually eroded. Beginning in the early 1980s, the Supreme Court reconceived its role in India's democracy through a series of procedural and substantive innovations. It is now able to hear a wider range of cases, including those on socio-economic rights, and monitor government compliance over time. Francis Correll Mullen versus Union Territory of India, 1981, established that Article 21 of the Constitution protects not only the right to life, but also a more expansive right to live with dignity. This has been interpreted in subsequent cases to include a number of socio-economic rights, including the right to education, housing, and health care. The right to food was recognized as part of the right to live in PUCL versus Union of India 2001. This case originated as a PIL filed in response to a famine that affected millions of Indian citizens across 6 states. Exercising its power of continuing mandamus, the Supreme Court has issued a wide range of interim orders in this case. These orders deal with several food-related and other socio-economic issues. The most significant order was issued on 28 November 2001. This order declared a fundamental right to food under Article 21 and directed the government to implement a number of schemes, including the midday meal scheme. The PUCL case remains open today, more than 13 years after the initial PIL was filed, and more than 50 interim orders have been issued. With this discussion, I hope you have been able to understand the scope of the right to food in the Indian Constitution and the important aspects of the landmark case PUCL versus Union of India. For further learning, you are requested to refer to the e-text and self-assessment resources. Thank you for listening.